Now, for the other side, Ashwani Kumar, former law minister, joins us now. Thank you, Mr. Kumar, for speaking to NDTV. You heard Mr. Salvi. Now, when the case is all about an alleged planned role in Delhi riots, can a long time in jail alone be enough to justify bail under an anti-terror law? By giving bail to some accused and not to the others, many feel that the court has shown that each case is judged on its own facts and not as a group, and that many feel is a good thing.
Well, the Supreme Court, in a series of judgments, have said that the accused have a fundamental right to speedy trial, and long incarceration without conviction is in itself a very major consideration in the exercise of judicial discretion to grant or not to grant bail. And this principle must hold true in all statutory instances, whether it is UAPA or PMLA. There have been a series of judgments in special statutory enactments also, where the court has said that Article 21 must have primacy over all statutory provisions when it comes to the liberty and dignity and privacy and reputation of an individual. And that has been the jurisprudence of this country, and that is the core of Indian democratic ethos. The fundamental aspect that you need to consider in this case is, why could the prosecution not bring home the guilt of the accused for 5 long years? Leave aside bringing home the guilt of the accused, not even begin the trial for 5 years. And is there a recompense for the loss of liberty of an individual who is merely suspected of a crime but is eventually acquitted? Who will be responsible for that loss of freedom? Please remember that in all the jurisprudential debates, whether it relates to a criminal statute or whether it relates to any other criminal provision,
right,
one fundamental aspect can never be lost sight of. Judiciary, particularly the constitutional courts, are meant to mediate between the citizen and the state when it comes to matters of liberty and fundamental rights. Who is responsible for bringing home the guilt of the accused? Beyond doubt, it is the prosecution. If the prosecution has not been able to do so for 5.5 long years, must an accused suffer? That's the principal question. Now, what is surprising in this otherwise very eloquently written judgment is the court's observation that it is not persuaded that the long detention has crossed the threshold of constitutional impermissibility. These are the words from the judgment. Now, pray, ask the court, where is the threshold of constitutional permissibility laid down? It is laid down in the exercise of their discretion and by the exercise of their discretion. And that is why now the court has said, we give you 1 year to expeditiously try the case, and then liberty is granted to the accused to apply for the bail. Okay. Now, this is nothing but an exercise of discretion. I ask myself the question, why could the court not have said that 5 years long incarceration without bringing home the guilt of the accused is good enough? That's the threshold, and we will not allow further detention of these people without even a trial, leave aside conviction. Right. That should have been, in my respectful submission, and I say so with the utmost deference to the highest constitutional court, for which I have great respect, that should have been the discretion that the court ought to have exercised. Therefore, one other point which I want to make, please remember, India is no banana republic. India is a sovereign democratic country of 140 billion people. The question remains, can 2, 4, 5, 10 people accused of harboring designs to disrupt the unity of India challenge the constitutional conscience of the country? The question is, right now, with all the offenses arraigned against them, they are merely accused.
Right.
Nothing has even begun.
Right.
Therefore, they should get the benefit of the constitutional conscience of the Constitution.
Mr. Kumar, valid point here, but you also heard Mr. Salvi, and there are many experts who believe that in cases linked to national security, and this is one such case, it is reasonable for law to put public safety over personal liberties, at least till the trial is completed. So, I mean, I know you're talking about a balance here, you're talking about something that needs to be done, but you just heard Mr. Salvi, who says that, this is India is an island of democracy, and there are countries going completely berserk with protests all around us. So this is about national safety, national security, and keeping our citizens safe. So how will you even counter an argument like that?
Well, I don't comment on individuals. I have my own views, and my view is absolutely clear. The routine invocation of national security can never be a justification in a true democracy to deny people their freedoms. Where is the democracy without the freedoms of the citizens? The state exists for the citizen. The citizen does not exist for the state. It is the citizen and the individuals who have consented to confer authority on the state in the interest of both collective security and collective good of the people. But if in the process the state itself becomes oblivious to the need to safeguard and protect and zealously preserve the liberties of individuals, then I think there is a question mark on democracy itself. Substantive democracy is about rights. It is about fundamental rights. It cannot be about a criminal justice system where the process itself becomes the punishment. Please ask yourself this question, which I do all the time. Is there a recompense for the 5 years of lost liberty of these people in case they are acquitted? There isn't. So if there is no recompense for an injury, it is better to minimize that injury on your own citizens rather than to perpetuate that injury. So why is it that a citizen has to knock at every single door, at every level of the judicial process for just the freedom to be? Yes, I can understand heinous crimes of any nature must be punished. There is logic in the retribution system of criminal law, but it is only after the guilt is established, not before. What happens to the presumption of innocence? What happens to the principle that bail is the rule and jail is an exception? What happens to the sacrosanct principle of constitutional law in this country, that Article 21 is at the pinnacle in the hierarchy of fundamental rights, and all statutory provisions have to be interpreted to be in consonance with the spirit and letter of Article 21. This is the judgments of the Supreme Court in several cases.
Right.
This particular judgment seems to be diluting that principle, and that is my difficulty with this judgment.
Absolutely. Mr. Kumar, thank you so much for making those points. Former Law Minister Ashwani Kumar there. Thank you so much for joining us.